Stormy Daniels' lawyer, Michael Avenatti, tells CBS this morning that he wants this case to prove that President Trump and Michael Cohen have told the American people, in quotes, a bucket of lies. He says that he wants the truth about President Trump's role in the $130,000 payment to Daniels in 2016 to be revealed.
The motion is not crazy. I mean, we're relying on U.S. Supreme Court precedent and a whole long line of cases in the Ninth Circuit Court of Appeal. It is well-founded. It was well thought out. It's incredibly documented.
What do you want?
What we want is we want the truth. I mean, we want to know the truth about what the president knew, when he knew it, and what he did about it. As it relates to this agreement, we're going to test the veracity or the truthfulness of Mr. Cohen's, his attorney's statements. And we're confident, Gail, that when we get to the bottom of this, we're going to prove to the American people that they have been told a bucket of lies.
The motion references a meeting on March 21st. What happened at that meeting?
We had a what's called a meet and confer, where both sides confer about impending motions. We raised this motion with the other side, and I think one of the things that was significant during that meeting was we asked Mr. Harder, Mr. Trump's attorney, whether Mr. Trump was a party to this agreement, and we heard crickets. They don't know. He said they don't know yet whether Mr. Trump was a party to this agreement. How do you not know whether you're a party to an agreement unless you're just trying to make it up as you go along?
You're essentially arguing this is bigger than Stormy Daniels now, that this essentially agreement was an effort to influence the 2016 election. What would the judge need to be convinced of in order to grant your request in order to have a deposition of the president?
We don't think it's a big stretch. The other side is attempting to force this case into a private arbitration hidden from the public, where the public doesn't learn what really happened. In order for the judge to determine that, we are arguing that under the law, we're entitled to the deposition. Quite honestly, there was a mistake by the other side in pushing this case into federal court, and now we're going to bring it to bear.
You heard Paula Reed make reference to the statement from the spokesman for Michael Cohen, who called this a reckless use of the legal system, but went on to say, in order to continue to inflate Michael Avenatti's deflated ego and keep himself relevant. This is a politically motivated, and people see through this charade.
Mr. Schwartz is a hack straight out of Central Casting. Next question.
If the president agrees to a deposition only, but it were under seal, would you agree to that?
We would fight that. I can't imagine that the public would sit for that. But I mean, obviously, if the judge ultimately decided that, we would adhere to it.
You mentioned Clinton versus Paula Jones in your motion. Why is that relevant?
Well, it's the Supreme Court precedent. The Supreme Court already decided that a sitting president could be deposed in connection with a civil matter. And if that was the law then, it certainly is the law now. It hasn't been overturned.
If they came to you with a settlement in this case, would you accept it?
Well, I think we would consider it. I would converse with my client. It would depend on the terms of the settlement. But I mean, at this point, I don't see how the case gets resolved short of the truth coming out and the whole truth for the American people.
Yeah, you called Mr. Schwartz a hack and then moved on. But I also think, you know, a lot of people, Michael, are saying that you're a hack too, that this is all politically motivated. What do you say about that? That this is really nothing more to attempt to embarrass the President of the United States?
It's just simply not true. I'm not involved in politics. I'm representing my client. The President and Mr. Cohen are the ones that have spread half-truths and falsities about my client. My client wants the American people to know the truth and nothing but the truth.
And quickly, when do you expect to hear from the judge?
We have a hearing set on April 30th, and both sides will argue the motion at that time, and the court will either render a decision then or shortly thereafter.
Did you have any trepidation about filing this to depose the President of the United States? Did you have any trepidation whatsoever?
None, because it's well supported by the law, and we're confident in the motion.
All right, for more on this, let's bring in CBS News legal analyst Rikki Klieman. Good to see you, Rikki.
Nice to see you.
So what are the chances that this federal judge in California approves what Michael Avenatti is asking for?
Well, there's a number of things that Michael Avenatti is asking for. Number one is he has to get the judge to agree that under the Federal Arbitration Act, that this is going to be a case that is decided in the federal court, an open forum, rather than being kicked back to an arbitrator. What we haven't seen yet is the defense filing that's going to say it belongs in arbitration. Second, he has to approve or not expedited discovery. Well, expedited discovery may be the hardest one, because why is this of such earth-shattering importance that it must be done now, that it must be done within 90 days, that we would have a jury trial? Why isn't it something that can go in the normal course? Who is being harmed here? And the answer to that from Michael Avenatti is, well, Stormy Daniels continues to be harmed all the time because of the defamation that has happened once before, and you bet your bottom dollar he's going to be looking for any comment that will say it's happening again. But also, Michael Avenatti has said that because of public policy, and this is where his most sound legal arguments are, because of public policy, this non-disclosure agreement should be declared null and void. And he has plenty of case law to back that up. And that's about the public interest, because you have a candidate for public office who may have done something wrong or not, but that it deserves to be exposed.
So Michael Cohen has a lawyer of his own, David Schwartz. He's speaking for him now. And David Schwartz says, look, it's pure speculation that this $130,000 has anything to do with the election, despite the timeline, despite the fact that it was just 11 days before the election. He spoke to CBS Radio. Let's listen to what he had to say.
It's a reckless use of the legal system. That's what it is. My client, Michael Cohen, is going to use a court of competent jurisdiction in order to fight the case in the courthouse, not in the court of public opinion. There's nothing surprising about this latest motion to depose the president and to depose Michael Cohen. And those issues will be sorted out by the court.
Well, your response to that?
Well,
I mean,
he's right. He's right. They will be sorted out by the court. There is no question about that. The reality is this. You have to go to specific proof if you're going to look at the Federal Election Commission violation, that is the FEC violation, let alone the public policy violation, if we push back that Michael Cohen did this either at the instruction or with the knowledge or with the acquiescence, of then Mr. Trump. But what you're looking at here is, of course, they're going to say, well, you do settle claims, whether they be true or false. Every lawyer who's been engaged in these kind of NDA, non-disclosure agreements, there are times when you may not believe the allegation, but a person doesn't want their family to know, doesn't want their employment to know, someone doesn't want to be held up to scorn and ridicule. So these kinds of things are settled. So it's up to the plaintiff, which is Michael Avenatti and Stormy Daniels, to show that the timing of this was more than coincidental. You have Access Hollywood tape in October of 2016. It becomes the talk of the media. Then you have October 28th, this hush agreement, as it's been called, is signed 11 days before the election. Well, that's some powerful coincidence, quote unquote, for Michael Avenatti to give a judge.
So how did we get here? It's interesting that Mr. Avenatti says that Michael Cohen's spokesperson is a hack. On the other hand, what the Cohen camp has said is that this lawsuit, the idea of getting the president in front of to do this deposition, certainly there's Supreme Court precedent. They name Jones versus Clinton. But how did we get here to this point?
Well, we got here because of Michael Cohen. And I think that as I look at the events, in my legal opinion, this is what happened. Michael Cohen either, as he says, out of the goodness of his heart, because he would always protect Mr. Trump, goes to quash someone's story, and he pays money for it. By the way, that's legal. You can do that. But if you pay money for it for a more nefarious purpose, that may not be legal. So he goes to get this agreement all set up, signed, puts up this dummy corporation, the money goes through it, the money gets to her, but President Trump is not signing the agreement. So you already have one deficiency potentially about the agreement. Then the story comes out in January from the Wall Street Journal, and Michael Cohen is the one who makes the comment. He goes forth and he goes to explain himself about why he says this is not an FEC violation, because this has nothing to do with the Trump organization or the Trump campaign. He just did this all on his own. No one over there knows anything about this. And then he goes and he makes this fatal statement. He says, just because something isn't true doesn't mean it cannot cause you harm or damage. I will always protect Mr. Trump. So that causes the defamation claim, which they didn't have before. And so now they can ask for a jury trial and damages. So at each place along the line, it seems that Mr. Cohen has made some errors, or what people might consider to be errors, that have caused all of this.
Is it important? I mean, Michael Cohen says that he's sort of like this Ray Donovan character, which is a fictional character on television.
Well, I like Michael Clayton.
Did he say that about himself?
Yeah, he's tweeted about himself as Ray Donovan.
Well, let's remember this. Ray Donovan walks around with a baseball bat.
Well,
let's not forget that.
Right,
fact.
and so that's my question, right? He sees himself as this like sort of fixer in a fictional sense, but when it comes to the actual legalities, the law, is he deficient? Because it seems to be that with what you're suggesting here is that he hasn't protected his client in the ways that perhaps another lawyer who was, I don't know what the word is, but probably a better lawyer would have done.
Well, he certainly would have done better if we had gone all the way back to the beginning and he had left Stormy Daniels alone. But even if we get past that point, once you start making public comments, you've opened the door for that person to somehow have to defend themselves. And if you look at the lawyering here, one of the greatest arguments that Michael Avenatti has is the unconscionability of this contract. That's another legal term. She gets $130,000, but every time she breaches, just her, not them, every time she breaches, that means she has to pay $1 million. There are all kinds of covenants that she has to do things, and they don't. So the result of that is you can see where the power was in the negotiation or lack thereof of this contract. Courts don't like those kinds of contracts. In the old days, there are bigger corporate contracts. We call those contracts of adhesion. These are, you have unenforceable positions because they are unconscionable. Then when you add the public policy factors to it, you may really have a mess on your hands, which if you had either left the whole thing alone, because there were all these other women who were saying that Donald Trump had touched them inappropriately. Stormy Daniels says it was consensual. If he had left her alone, the story would have been a one-day story, and we would not be here.
Very quickly, Summer Zervos and her attorneys watching this very closely, I presume?
I assume that Summer Zervos and her attorneys not only are watching this closely, you have to remember, she's now in the state of New York. She has a case where she is now allowed to go forward with a defamation claim because Donald Trump called her a liar. Everybody sues everybody for defamation because somebody says they're lying. And she's definitely going to get to depose him.
Very interesting. We'll definitely have you back, Rikki Klieman. Thank you.